Morning.
Morning, Your Honors. Cameron Price for the appellant, Mr. Santory Johnson. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
You may proceed.
Thank you, Your Honors. May it please the court. On December 5th, 2018, Santory Johnson's Rule 11 petition was denied by the Tennessee Supreme Court. He did not know that at the time. He was not notified of that at the time. Due to circumstances beyond his control, he had been effectively abandoned, though unintentionally, by his attorney, who'd handled his appeal and his Rule 11 petition. She had changed law firms, and she had apparently relied on employees and staff at her prior law firm to notify Mr. Johnson of the status of his case, and that does not seem to have happened. The first that Mr. Johnson learned of his denial of petition was on March 27th, 2020. That was approximately 3 months after the statute would have told for him to file a post-conviction petition. From that date, and since that date, Mr. Johnson has been diligently pursuing his rights and his post-conviction petition. There's a little bit of back and forth with his attorney in order to get his record. That took place from March to August of 2020, which was COVID times, and there were certain restrictions that created some problems there. But on August 25th, he received a physical file that he could access, and 6 days later, he filed a pro se post-conviction petition with the Criminal Court Division II in Hamilton County. Judge Greenholtz at the time issued his preliminary order based on that petition on September 14th, 2020, making several findings. He found that the petition may have raised a couple of colorable claims for relief, and furthermore, and importantly, may have raised a couple of claims that would justify the due process tolling of the statute of limitations. Specifically, Mr. Johnson referred to his attorney's failure to notify him about the deadline and the fact of his denial by the Supreme Court. Judge Greenholtz ordered that if Mr. Johnson wished to have appointed counsel, he could file an affidavit of indigency, and and counsel would be appointed to handle his case going forward. He did not file an affidavit of indigency. He said he could not get one, but he mailed the clerk and said he wanted appointed counsel. Judge Greenholtz found him indigent, I guess, and set a hearing for January 6th, 2021. At that hearing, he was appointed John McDougall. He was transported to Hamilton County Jail, and he was appointed counsel. There's a long procedural process, which I can expand on if necessary, but I won't go into it now. It's all outlined in our brief. Importantly, what happened is that on December 2nd, 2024, this is 3 years later, or 4 years later, a motion to dismiss hearing was had. The state had filed a motion to dismiss about a year earlier, and at that hearing, Mr. Johnson's counsel withdrew. Mr. Johnson was forced at that hearing to proceed pro se, did not ask to proceed pro se, but he was forced to proceed pro se, and the court ultimately dismissed his motion on timeliness grounds. Importantly,
But he lost his fourth lawyer, right?
that was his fourth lawyer. Yes, he was appointed a lawyer in January.
It was only after he basically lost his fourth lawyer for whatever reason that the judge told him he had to proceed pro se.
That's correct, Your Honor.
Oh, okay.
That's correct. There's nothing in the record to indicate that he was abusive to his lawyers or that he was in fact attempting to delay. In fact,
Well, if I remember the record correctly, is that he wouldn't meet with, at least the last lawyer he had, he wouldn't meet with him, wouldn't talk to him.
That's correct. The last lawyer attempted to meet with him once, and he wouldn't meet with him, and then attempted to meet with him the night before the hearing, and he refused to come out of the pod.
Right, he said he won't come out on a Sunday or something like that.
Because he was in custody, so it's not like he had to make an appointment with his lawyer. I mean,
No, that's correct, Your Honor. He was, at that point, he was being held at the Hamilton County Jail, and they have a system of pods, and he didn't come out of the pod. And that was at 9 o'clock or something like that, the night before the hearing. In any event, he proceeded pro se, and I submit that as a pro se defendant, he actually managed to put on sufficient evidence for this court to find that due process tolling of the statute is justified in this case. Specifically, he entered into evidence his mail log, and the mail log clearly shows that he received legal mail prior to the Supreme Court's decision to deny his petition, and then no legal mail whatsoever until March of 2020, 3 months after the statute would have expired. Furthermore, his amended petition, which was properly verified, was entered into the record, and in that he states that he didn't know and he wasn't notified. The state didn't actually rebut any of that. The state's theory in arguing for dismissal was that in September of 2020, when Judge Greenholz issued his initial order, that he had sort of extended the deadline for a post-conviction petition and created a hard deadline of December 1st, 2020. That's not actually what Judge Greenholz did. What he did was he said you have to file by December 1st, 2020, a verified petition and or ask for counsel. What he ended up doing was asking for counsel, and Judge Greenholz proceeded on the basis that he needed counsel to draft and file his amended petition. And that's what took place. A lot of work was done to file his amended petition. I believe the amended petition was filed in 2023. It was his second lawyer who filed the amended petition. And in that amended petition, he raises the exact issue of attorney abandonment that would form the basis for due process tolling of the statute. He was never put under oath at that hearing. He did testify he spoke, but he wasn't ever actually sworn. But I would argue that his sworn statement in the form of his amended petition was in fact evidence. The mail log was in fact evidence. That was entered into the record with no objection from the state. And the state didn't really even argue about that.
Well, let me stop you for a second. When do you say he found out about the Supreme Court ruling?
In March 27th, 2020, 3 months after the statute would have passed.
When did he file his petition for post-conviction relief?
He filed his petition.
The pro se one.
I believe it was September 1st, 2020, but that was about 6 days after he'd received his case file.
Okay, but so he found out about it in March. He didn't file it until September.
He immediately contacted. He was communicating. It's a little strange, I would acknowledge. He's communicating with his attorney through the Board of Professional Responsibility. But he is in communication with his attorney, and they make 2 attempts to get him his case file. The first attempt, I think she sends it to him in June, but she sends it electronically. He can't get in the law library because of COVID. And so then he sends her a letter saying, hey, I can't get the case file you sent me. And so she sends him a physical copy of his case file, and then he immediately files his petition, or almost immediately files his petition. And it's that filing date that's an issue, right? That filing date is controlling, and the state acknowledges that in their motion to dismiss. The date of the pro se filing is the date that matters as to whether or not the petition was timely. The fact that this has taken 4 years is not really relevant.
Well, I'm not concerned about. Well, I am a little concerned from the standpoint of the way he dealt with his attorneys, but the state is making an argument that, as far as due diligence is concerned on his part, that there was a pretty long delay between when he found out about the Supreme Court order and when he actually filed his pro se petition.
I think, well, I'm not sure the state ever made that argument. The state below argued that it had been, that it was a long time before he filed his pro se petition. I'm not sure that they actually ever really acknowledged that he was late in receiving it, but their argument below was largely that it had been that he filed his pro se petition, 3 months after, or 6 months, 8 months after the deadline, and then having been given a hard deadline by by Judge Greenholz, they argued that he missed that deadline as well, and that was really what was pivotal in the trial court's reasoning. He said, Judge, the trial court refers to it as largesse. The Judge Greenholz gave you this additional largesse, extended it to December 1st, and you missed December 1st. But of course, he didn't miss December 1st. After December 1st, 5 weeks after December 1st, Judge Greenholz appointed counsel for him. And I would argue that once he's been appointed counsel, the machinations that were going on about filing the amended petition, my client couldn't be expected to do anything about that. His counsel were acting on his behalf, and they were in fact moving forward. And his second attorney did a lot of work to file his amended petition, and it took him over the course of about a year, and that petition was properly verified and everything else.
There's a question I have going back to the issue on forfeiture of counsel. There's a reference from the post-conviction judge saying, at the last hearing, I told you if you didn't get along with this one, you're on your own. And it appears, from the best I can glean from the record, that was an October 28th hearing, which we have no record of. Did that actually happen? What was said by the trial judge to the defendant? Do we know?
Candidly, Your Honor, I don't know. I wasn't present at that hearing, and I don't know. And my only argument there would be that it's certainly possible that there was something said that the judge made findings of fact at that hearing. But I think it would be reasonable to expect the judge to make findings of fact at the hearing where he's actually forcing the defendant to proceed pro se. But all that said, I would submit that he provided sufficient evidence at the hearing because to the extent that he was diligently pursuing his post-conviction petition, the time that matters is the time between March 27th, 2020 and September 1st, 2020. That's the period in question, because on September 1st, 2020, his post-conviction petition is filed. It's inadequate, but it's filed, and that's the controlling date, as the state acknowledges.
Okay, and I may have just misunderstood what you said. Okay, at some point in time, did the post-conviction court find due process tolling? Is that what you said?
No. Judge Greenholz, in his preliminary order, found that the pro se petition may have raised issue. It raised facts which may have implicated due process tolling, and that a further hearing would be necessary to establish that. And that's essentially what that December 2nd, 2024 hearing was, or should have been.
But the judge didn't make a determination that...
He did not.
Okay, all right, I misunderstood. Thank you.
No, he looked at it as though that December 1st, 2020 date was a sort of grace period or an extension.
And so really the Judge Patterson, I guess, was the last judge.
That's correct, Your Honor.
Involved in this, and he said that there was no due process tolling.
He did not explicitly say that. He said that he said
it wasn't timely filed.
He said it wasn't timely filed. That's correct, Your Honor.
All right, so if you find that, then you're not, and he knew that due process was technically an issue. I guess that's a
I believe that's correct, Your Honor.
Okay, all right, thank you. Counsel? Or General, rather?
Either one. Good morning, and may it please the court. Caroline Weldon on behalf of the state. This court should affirm the post-conviction court's dismissal of the petition because the record is inadequate to determine the petitioner's right to counsel claim, and the post-conviction court properly dismissed the initial petition as untimely. So how did we get here? Counsel has traced the chronology, but I have a few different dates that I'd like to point out to this court. So I apologize for getting into the weeds so early in the morning, but it's important to to understand the timeline, to understand the petitioner's claim. So the petitioner was convicted of second-degree murder, which this court affirmed on direct appeal, after which the Tennessee Supreme Court declined to exercise its discretionary review and denied his Rule 11 application on December 5th, 2018. More than 1 year later, on August 18th, 2020, the petitioner delivers his first unverified pro se petition for post-conviction relief officials at the prison. The post-conviction court received it and directed the petitioner to file on or before December 1st, 2020, a verification of the truth of the allegations in that petition. And in that order, the post-conviction court said that it would schedule a hearing to determine first the timeliness of the petition once it received that verification. And it was very clear what the post-conviction court was directing the petitioner to do and the time by which he needed to do it. The petitioner does not do it, as the post-conviction court directed, but wrote a letter requesting counsel. So the post-conviction court appoints counsel, his first attorney, on January 6, 2021. The next year, February 4th, 2022, the post-conviction court appoints a second attorney. The following year, January 10th, 2023, the petitioner finally files an amended verified petition. And in that petition, he claims that his trial attorney filed the Rule 11 application on his behalf and never told him that it had been denied, blaming her for his delay in filing. So after he files that amended verified petition, he then asks for that attorney who assisted him in preparing that document to be removed in October of 2023, and the post-conviction court appoints another attorney, Mr. Davis. The following year, the petitioner asks for that attorney to be removed, and the post-conviction court appoints Hunter Bishop. Later that same year, the petitioner asks for that attorney to withdraw, and Attorney Bishop appears in court, and he says that the petitioner had refused to meet with him to prepare for the hearing date and requests to withdraw on that basis. But the post-conviction court at that point basically says, enough is enough, denies his request, and says, they need to get along, we need to have this hearing finally. So the night before that hearing is to take place, that attorney goes to the jail to meet with the petitioner, and as this court has mentioned earlier, the petitioner refuses to meet with him, refuses to leave his pod to come out and prepare with him for the hearing tomorrow. So the attorney appears in court on that hearing date and explains what happened to the post-conviction court and says, I cannot represent him if he refuses to meet with me. And at that point, the post-conviction court says, I told you last time that if you can't get along with Mr. Bishop or work with him, that you be representing yourself so you can have a seat. And that's all we really have to go on as to what the post-conviction court had relayed to the petitioner at all of these earlier court dates and status hearings and everything else that transpired over the years that preceded this final hearing in December of 2024. We don't have the records showing what other admonishments were made by the post-conviction court. We don't have it. So without understanding the full extent of what those hearings entail, this court is unable to really address or really examine the petitioner's claim as to his right to counsel at this hearing. And at the hearing that followed, the petitioner represented himself, and he was unable to offer a satisfactory explanation for why he did not file his petition within the 1-year statute of limitations as required. And from this, the post-conviction court found that despite the extraordinary flexibility that he had been given with all these attorneys and this additional time to prepare, that he had failed to do what he needed to do and dismissed his petition. And so the petitioner continues to complain that the post-conviction court forced him to proceed without an attorney and failed to make any findings as to its justification. But at the same time, he acknowledges that the court warned him about this possibility during earlier status dates, but again, he has failed to include those transcripts in the appellate record, and that it was his duty to prepare an adequate record for this court's review. So turning to the record that we do have, it is readily apparent that the petitioner forfeited representation by counsel. He has a constitutional right to counsel, but it is,
It's a statutory right to counsel.
yes, I'm sorry, excuse me, I misspoke. Yes, thank you. That's a key omission. Petitioner does not have a constitutional right to counsel in post-conviction proceedings, but it has been created by statute. However, that statute is not absolute. And here the petitioner was represented by 4 attorneys, 2 of which he sought to remove, and even after that 4th attorney was appointed, he refused to meet with him on 2 occasions, ignoring the court's warnings as to what would happen based on his refusal to meet with him. So as for his claim that the post-conviction court should have allowed him to continue the case so that he could prepare to represent himself, he made no such request for a continuance during the hearing, so that claim has been waived. And if there are no further questions about that long-winded chronology of events, I'd like to circle back now to whether that first unverified petition, and he acknowledges that he did not file that petition within the statutory time period and blames his attorney at trial for her alleged failure to advise him that the Supreme Court had denied his Rule 11 application. And he insists that her alleged failure to tell him constituted attorney misconduct that told the statute of limitations. And in support of that accusation, he points only to his mail list, which shows that he did not receive mail from his attorney during this period of time. But an alleged absence of mail is not tantamount to attorney misconduct. It is entirely possible that she told him about the denial by telephone, or met with him, or that the mail log is simply inaccurate. It's also unclear from the record where the petitioner was housed during this period of time, and it's possible that he wasn't in that facility and did not receive mail.
At some point in time, did that counsel testify that they didn't have a recollection one way or the other? Or did I misread that from somewhere, or am I misremembering that?
I'm not sure if Your Honor is referring to the letters that the attorney exchanged with the petitioner, because there was kind of a flurry of mail, and that is in the appellate record, where she's trying to get him his materials, his case file, and as counsel said, that she had changed firms, and so she was coordinating with her firm. But no, she did not appear to testify. No, Your Honor.
Oh, okay, all right.
She said in those letters a couple times, I believe, that he should have known the date. And then she says, I can't be certain he got the files. So from those, are you drawing the conclusion that she actually did tell him the date, or are you just saying we don't know?
I think my reading of the letter shows that she did tell him the date. She's saying, as you recall, referring to earlier letters, and while we don't, or earlier communications at least, and while we don't have those letters in the appellate record, that doesn't mean that they don't exist. It doesn't mean that he didn't know.
And then my next question from that is, let's assume that she didn't tell him. Is that the type of attorney misconduct that would result in a due process tolling? Or
No,
maybe something more?
No, Your Honor. It does not rise to the level of attorney misconduct. Even miscalculating the statute of limitations does not rise to the level of attorney misconduct. So just assuming for the sake of argument that she failed to tell him, it is still incumbent upon the petitioner to diligently pursue his appellate rights. And he knew that. He had gone through the direct appeal process. He was certainly aware that he had filed a Rule 11 application, and it was incumbent upon him to check on that and to know the status of that. And his failure to do so is on him. But it seems to me from the letters that we do have in the appellate record that his attorney had communicated that to him somehow, even if we don't have the exact one piece of paper showing that. I don't think that we can hang our hat on a mail log that might be incomplete or may not reflect the petitioner's location. Perhaps he was in another facility and received mail there, and a mail log at that facility captures it. We just don't know. And again, it is up to the petitioner to show that he is entitled to due process tolling because of attorney misconduct, and he cannot do that here. And again, it is his responsibility to keep tabs on his appeals as they wind their way through the court system, and he did not do that. And if there are no further questions, I'd ask this court to affirm the dismissal of his petition.
Thank you. All right, Mr. Price?
Thank you, Your Honor. Just a couple of points. First, as to the matter of attorney misconduct, I know that my friend has said that failing to notify is not attorney misconduct. In her brief, she cites to Brazelton. I would encourage the court to read Brazelton. I think it actually does not hold exactly that. What it held in Brazelton was that there was insufficient factual basis on the record to establish whether or not that had actually occurred. The case was remanded for further proceedings to actually establish a better factual basis. As to my client's former attorney's letters, they're lawyerly, and they say, she says, as you should be aware from communication from my previous office, I completed your appeal. The Court of Criminal Appeals denied your appeal. I applied to the Supreme Court for permission to appeal, and it was denied. As you should be aware. Yes, you should be aware. She believed that he should be aware, but she doesn't actually say that she knows that he was aware.
But again, it's, the burden's on petitioner to prove his point. And, you know, to say, based on this letter, I mean, the lawyer was never called to testify.
That's correct,
So
Your Honor.
you have a letter that's open to interpretation. How does that prove clear and convincingly that he was aware or not aware?
I would suggest, Your Honor, that two points on that. First, we had the mail log, so we can see the legal communication that is coming, and we see communications coming from the previous firm, but none after the Supreme Court has denied cert. And second, of course, we have my client's sworn testimony in the amended petition. And importantly, it simply wasn't rebutted by the state below. Those were facts that they allowed to come in, and they did nothing to rebut them. So I would suggest that there may well be sufficient evidence there. What we're asking this court to do is either find that due process tolling is warranted, or remand for further proceedings to establish a better factual record and come to that conclusion.
Okay. All right, thank you.
Thank you, Your Honor. Thank you.
All right. Madam Clerk, would you call the next case then, please? I'll trust you.
State of Tennessee versus Amanda Jean Phillips.